In the course of a law school career, a law student typically reads hundreds of cases. For the most part, these cases are abridged versions of appellate opinions. In this lesson, you'll learn how to read the real thing. That is, actual, unedited legal opinions. You'll learn the difference between the official legal opinion, which contains the actual language of the decision, and editorial enhancements, which are not part of the actual decision, but help navigate within a case and identify additional sources on the same subject. The words of the judge writing the majority opinion are a primary source of law, but any other part of the document, while interesting and often extremely helpful, is not the law and cannot be cited as precedent. A written opinion typically consists of three basic parts: the facts, the holding, and the reasoning. The facts spell out what happened in the case. This may not include all the details of what happened, but it will address the facts that give rise to the legal questions that the opinion resolves. The holding is the answer to those legal questions. The reasoning is a discussion of why those answers are what they are. In addition to these three main sections of primary law, opinions often contain what is called dicta. This term comes from the Latin obiter dictum, which means something said in passing. Dicta results when the court strays off topic. Our lesson on searching will revisit dicta, as it causes problems in online research. Dicta can be used as persuasive authority, but as with many things in the law, people can disagree about exactly where the reasoning ends and the dicta begins. There are four different types of appellate opinions: majority, per curiam, concurring, and dissenting opinions. Majority opinions may sometimes be called lead opinions, especially if they command only a plurality of the judges. There may also be partial concurrences, partial dissents, or even opinions that partially concur and partially dissent from other opinions. Appellate judges and justices sit in panels and decide cases as groups. Typically, a single judge writes the majority opinion, which includes both the holding and reasoning. Sometimes the court may issue a per curiam opinion, which does not identify the author. Per curiam is Latin for by the court, and it means that the judicial panel is speaking with one voice. A judge writes a concurring opinion when the judge agrees with the lead opinion's holding, but for different reasons. If a judge disagrees with the court's holding, he or she will write a dissent. Concurring and dissenting opinions are not the law, but can be cited as persuasive authority. Sometimes, when reviewing a lower court's decision, a higher court will adopt the reasoning from a lower court judge's concurrence or dissent. An appellate opinion begins with a caption containing the name of the court, followed by a listing of the parties. When the case was first filed at the trial level, usually the first name listed was the plaintiff's, and the second name listed was the defendant's. At the appellate level, the party that filed the appeal is identified as the appellant or the petitioner. The other party is listed as the appellee or the respondent. But as the case progresses through the appellate process, the names sometimes switch back and forth. Court rules from the various jurisdictions differ as to exactly how the party names are listed. The only way to know for sure is to read the procedural posture of the case and sort out which party is which. Although today most legal researchers find cases almost exclusively online, legal information providers continue to designate the citation of cases by the volume, reporter series, and starting page number. A published opinion may have multiple citations, directing the researcher to different collections of published materials. These are called parallel citations. When researching, it's a good idea to document all of them. Legal citation is simple and elegant. A typical case citation takes the following format: volume, reporter, page, date. The first part is the volume number in a set of books. The second part identifies the set of books, called the reporter, and may also include a series designation. The third part is the page number within the volume where the case begins. The fourth part is a date, which may also include which court issued the opinion if that information is not clear from the reporter. In this example, the two separate citations referring to Michigan appeals reports and Northwestern Reporter Second are parallel citations. Many print court reporters are issued in series. When the volume numbers get too high, the set starts over in a new series. This diagram shows that Michigan Appeals Reports is in its first series, whereas Northwestern Reporter is in its second series. This image shows the end of Federal Reporter second series and the beginning of Federal Reporter third series. Now let's talk about star pagination. A symbol, historically an asterisk, indicates the page breaks for a case in different reporters. For example, West's Supreme Court reporter will use star pagination to indicate where the page breaks are in the official United States reports. Internal page numbers are necessary for pinpoint citation for quotations. Universal citation solves this problem. Universal citation, also called public domain citation or medium neutral citation, is just that, neutral. That is, it doesn't matter what source the legal researcher consulted, the numbers will always be the same. These citations are often based on docket numbers rather than printed volumes, and paragraph numbers rather than page numbers. So it doesn't matter whether it comes from a computer or a book, the numerical references stay the same. So what's a docket number? In order to track all proceedings from a particular court, the court clerk assigns each case a unique tracking number that will appear on all the pleadings and orders relating to that case. Often the format of the number indicates whether a case is a civil or criminal matter. In a reported opinion, the docket number appears following the names of the parties. The next thing is a list of dates indicating when the case was argued, submitted, or released. The important date for citation purposes is the date on which the case was decided. The next item is the syllabus or synopsis, which is a summary of the case. The syllabus will provide the procedural history, that is, who sued whom and for what and who appealed, as well as the pertinent facts, a very brief recap of the reasoning, and the holding. Next come the headnotes. Headnotes come at the beginning, and they summarize each significant legal issue discussed in the opinion. The headnote number is repeated in the main text where that issue is discussed. In this way, headnotes assist the legal researcher in navigating the opinion by locating the part of the opinion where the relevant issue is discussed. After the headnotes come the names of the attorneys who briefed and argued the case, and the names of the judges who heard and decided the case. The words of the opinion, or the part that is the law, is found following the author's name. The last name is followed by the letter J, which stands for judge or justice. Concurring and dissenting opinions also list their authors' names in this way, but the lead opinion always comes first. Many appellate opinions have footnotes. Do not skip them. Footnotes in the lead opinion are considered part of the official text and are often cited as precedent. Sometimes it seems like the most important information ends up in the footnotes. For example, Michigan Court of Appeals Judge Gillis, in a case called Fisher v. Lowe from 1983, wrote the opinion in the form of a poem and put the law in the footnote. Next, when a case includes multiple opinions, the opinions will generally be organized in the following order. The lead or majority opinion, known as the opinion of the court, appears first. Concurring opinions follow, then dissenting opinions, if any, are included last.